When someone asks for feedback as to why they were not hired, please encourage your managers and everyone within hearing of my voice. Either don't do it or do it very judiciously after long, thoughtful considerations.
Good morning, HR. I'm Mike Coffey, and this is the podcast where I talk to business leaders about bringing people together to create value for shareholders, customers, and the community. Please follow, rate, and review Good Morning HR wherever you get your podcast. You can also find us on Facebook, Instagram, YouTube, or at goodmorninghr.com. Well, it's the end of December and the end of 2023. And returning to the podcast to talk about a few recent HR news items is my friend Julia Gannaway. Julia is a partner at the law firm of Ross Gannaway, where she counsels and represents public and private sector clients. Welcome back to Good Morning HR, Julia.
Thank you. Good morning, Mike. It's my privilege to be here with you.
And happy holidays.
Yes, of
We're
course.
right in the middle of them.
We are. I think you and I may be the only two people working.
I think that's probably about right. Yeah. And so we're recording this on Tuesday and we're dropping this episode on Thursday, which means we currently don't know the outcome of the Texas Bowl.
Yes.
So A&M is meeting OSU, and I know you're a big Aggie.
Yes,
so
I am.
dare I even ask what your predictions are for the Texas Bowl? Because by the time this drops, it'll be history. So everybody will know whether you're prescient or not.
Yeah, well, I'm always going to pick with my heart, so it's going to be the Aggies, just saying. So that's my heart and my hopes. So, yeah, and it's a good thing we didn't record afterwards, because if it had been the other outcome, then you'd have Miss Surly here before you. So right now I'm optimistic and hopeful. So,
good.
Yeah.
Best of luck to the Aggies,
Thank
I think.
you,
So.
Thank you.
And speaking of winners and losers, it's been an interesting month for companies before different regulatory agencies and courts, and we've got a few of those queued up to talk about. And the first one, let's talk about Whole Foods. Way back in 2020, which seems like a lifetime ago, they had an issue where they told employees, hey, we've got a dress code, and you've got to comply with it. And that included no insignia or pins or things that supported, had logos or supported outside causes. And a group across the country of Whole Foods employees were wearing Black Lives Matter related stuff, masks and pins and things, even writing on their shoes. And Whole Foods enforced their dress code and told people you couldn't do that. And so it went to first there's a Title VII case in the First Circuit, then there's an NLRB case. So will you just kind of go through what the arguments were on the Title VII case? What would how did that go? And then we can get into the more recent NLRB decision.
Well, yeah, thank you for setting that background, Mike. I mean, because really what the backstory, that sets the backstory for what did result in the NLRB. The case with Frith versus Whole Foods marketing, and of course that its parent company Amazon as well, and it was ultimately went through the district court and the First Circuit, and that was ultimately cited in 2022. But the racial allegation claims, they were saying what the plaintiffs attempted to assert, that this was racial discrimination because they had previously, Amazon and or Whole Foods had allowed individual expression of causes such as anti-discrimination against LGBTQ issues and other social issues, had allowed some speech, and more importantly, corporate speech had been opposing discrimination and all of those things. So what happened was, after the George Floyd protests came around, they started wearing the masks with the slogans about Black Lives Matter. And they said, Black Lives Matter is a statement against discrimination. and racial discrimination, and we are going to, oppose this, and therefore we want to. We find that it's Title VII. Just it's covered by Title VII because it says they had a 2 count complaint against Whole Foods, and they said racial discrimination and retaliation, and they wanted to seek class certification. Well, the trial court granted the motion to dismiss on the part of the defendants because the district court found that the uh, the plaintiffs did not assert and did not state that they were treating individual plaintiffs differently, regardless of the person who wore the mask, who made the statement. All of them, regardless of race, were treated the same, i.e., it was a class wide, every employee was prohibited from wearing all things and then beginning to enforce the dress code. So, what happened was before that, they didn't enforce the dress codes. They said because they started enforcing the dress code, that was racial because they think that Black Lives Matter was the reason. And they said, the difference in race of the employees, because the plaintiffs themselves said that it didn't matter. Therefore, it's no race discrimination. Then you've got also retaliation. They said you can't have a retaliation claim that says this enforcement action happened on a neutral, and across a uniform basis. The retaliation, you can't have a retaliation claim when they say ahead of time, we're going to enforce the policies regardless of reasoning, and they start enforcing the policy. They can't say, oh, they're retaliating against me because of Black Lives Matter. They said you can only really have retaliation if they had the action after you had made the Black Lives Matter statements.
There were employees who were protesting outside of the store about the policy, and employees and customers and just the public in some locations. And Whole Foods didn't do anything to really come down on that. It would be hard to prove, they didn't take any action against those employees based on their protests or anything like that. They just made them follow the policy when they were at work, right? So,
Yeah,
but
and real quick, I think I wanted to make a more cogent point. Hopefully, that the issue is that they did not take employment action against them for the protesting. What they did is they sent three employees home without pay for wearing the mask, and um, they said that also to prove retaliation and discrimination, they gave the business owner Whole Foods credit for having an obvious alternative explanation, and the obvious alternative explanation was what Amazon and Whole Foods wished to do was to have non-controversial topics at the forefront of their customer service situation. So the fact is, they decided to take a across the board approach to avoid controversial reasonings, regardless to whether it was not, you cannot infer or assume that it was obviously racial when in fact it was, we don't want to spark controversy and any other culture war with our company. We're here to
right,
sell
make
groceries
money.
and deliver stuff. We're not here in that format. So instead, we're avoiding controversy. We're not discriminating. And so that's why both the trial court and the appellate court dismissed it, because they found that they could not, plaintiffs were just saying it, but there was no reason other than there's no proof other than just saying it that there was any nexus with discrimination or discrimination intent, which sets the scene for the NLRB.
Right. So we get our good friends at the NLRB who've, especially with their general counsel's office, have never found a pro-employee position that they weren't willing to take.
Particular.
And so these folks ended up with talking to the National Labor Relations Board, saying this is a violation of Section 7, our ability to come together for mutual aid and comfort. And they end up in front of an administrative law judge, which is the last place you ever want to be if you're an employer generally. and especially an administrative law judge, I believe in San Francisco. I mean,
Of all
that
the
is the
crazy
last
places.
ALJ I want to ever be in front of, right? If I'm an employer. So what happened there?
Well, yeah, what was interesting was the NLRB general counsel, who of course is appointed by the current president, argued that the workers' perception was that Whole Foods' enforcement of the dress code was racist and therefore discriminatory. And then, so therefore, their perception was that their prohibition was discriminatory racist. So therefore, when they decided to wear the masks and have the different things affixed to themselves about Black Lives Matter, that they were, um, you know, they were defying the corporate rule on the prohibition of the no slogans, all of those things, that they still had the same policy was at issue. And I think it's important to note in the lawsuit and then of course in the NLRB action. And but the ALJ did not agree with their assertions. I think what was interesting is, as you got the thread, when the court said individually those people can't prove, or as a class can't prove racial discrimination or Title VII, then like, oh, that's concerted action. Let's go back. And so you're exactly right with the National Labor Relations Act, and about concerted activity. But what was important to notice, the ALJ said that Black Lives Matter, they could not show any link to the National Labor Relations Act and concerted activity because Black Lives Matter was unrelated to their work, right? They're
Right.
in the business of groceries and deliveries, not, and so they said that the acting in concert with one another, just because you're acting in concert doesn't give you carte blanche to disobey reasonable rules. And they said it to disobey an otherwise valid rule, nor makes.
Yeah, we could all decide to wear Taylor Swift T-shirts to work one day,
Mhm.
and the boss could tell us no, and it's not, telling us no isn't related to how we do our job or what they pay us or the terms and conditions of our employment
And
and
being a Swiftie is
basic.
not a protected class yet.
Yeah.
I mean, the legislature hasn't made
Yeah.
being a Taylor Swiftie protected class. But yeah, no,
Yeah, everybody's allowed to have bad taste in music, and so
hey,
they,
he said it, everyone reviewing this,
yeah.
not me. I mean, I love me some
Oh,
Taylor.
if I get canceled, it's not going to be for that. There's worse out there.
I'm just teasing you. No, but what they said was, and they also noted, they said and of course, Section 8 is about their abilities under their contracts and their collective bargaining. But they said, the collective bargaining agreement includes a grievance procedure. So the issue is that if you don't like something, you grieve it. You don't just decide to act in defiance and act in an insubordinate manner, to just blow off that rule. So that is why the judge, again, as you note, surprisingly, we could add our Texas
Mm-hmm.
observation to that, surprisingly disallowed or rejected the general counsel's argument. And they said, um, so they rejected that and said that is not the appropriate use of the National Labor Relations Act in that scenario.
And I thought it was interesting. The administrative law judge in his decision said, wearing BLM material wasn't protected, but pointed out that protesting the company's dress code was protected.
Mm-hmm.
But again, Whole Foods was smart, right?
Yeah.
They didn't retaliate for the protest part. So you can disagree with the company's policy and you can make that known and you can work together as a group of employees to protest that. And that's covered by the National Labor Relations Act. But as soon, but Whole Foods was smart. They didn't step on that. And they're lucky. I mean, that's the thing is you think about, how many stores they have and how many store managers they have and how many just in general in corporate America, how many kind of just unprepared managers there are for
Yeah.
these kind of issues. And I could easily see a manager someplace, retaliating against them, saying, "Hey, we don't want you out in front of our store protesting." And so, good job, I guess, to Whole Foods internal communications with their management and training. And probably as soon as this popped up at the first store, hopefully, I would imagine that their legal counsel reached out to their HR and their training people around the country and made sure everybody understood how to respond to this as it arises.
And they obviously took the lesson that was taught was to be taught through the court case, and applied it also to the National Labor Relations Act. So it was really a smart move, communications and management wise, from the very top on down, because they acted as an entity, not as an individual manager. They put their managers in a position to succeed and to not set them up for failure, and rather help them to succeed in a dealing with that, to make it not blow into a bigger deal than what it was. I'll say I believe that it's possible. Lots of things are possible, but sometimes people are like, let's see if we can, provoke a reaction from
Oh,
someone,
yeah.
and such reaction was not able to be provoked. So I thought that was good. I agree. Good. Two thumbs up all around.
And another thing that we've talked about on the podcast, and especially in the last several months, has come up is how many companies are stepping away from taking up public causes
Mm-hmm.
that aren't directly related to their business. I mean, Unilever's new CEO a few months ago just said, "Hey, we're here to make money. That's our first priority." And environmental social governance, ESG, and all of that. That's all great, but our first job is to make money, and that's what where everybody's coming to work for.
Yeah.
And more companies are stepping away from that, and some of it's because it's a distraction to getting the job done, but also a lot of them are realizing as soon as they start caving into one employee group or another about some social cause, they've lost the battle for all the others. I mean, it's the problem is you can't, as soon as you start cherry picking, you're going to start inflaming everybody and saying, we agree, uh, LGBTQ is fine, but this is not, and this, and why do you want to even create those headaches? We're here to sell tomatoes and crackers, and let's just sell tomatoes and crackers. And so, but on the flip side, employers have that issue about retaining those employees that they want to retain, and they want to feel, those employees want to feel like they belong to, to the team, and they're part of the, the group, and they're cared about and all that. So it's a thin line, but I think a lot of, especially after George Floyd's murder and on May 25th of 2020, a lot of employers felt a lot of pressure to jump both feet first into that, social justice swimming pool. And for some of them, it didn't work out so well, and turned out to be a big distraction.
Well, and I think you got to balance your need. Well, here's another thought. In 2020, when everyone wanted to jump into some of those things, maybe people wanted to feel collectively together because it was during the isolation of the pandemic. I
Mm-hmm.
mean, that is also something I don't think can be ignored. But I do think that the idea of that the corporate, it's interesting because a lot of the workforce now, as we're learning, the younger generations are coming out. They care about so many things more than just money you know, growing up through that corporation. They can jump ship and go somewhere else for better benefits, but also for, do they believe in the company they work for? And that's actually why you see people moving now. And so that's a cost that the employers have to deal with. But you're exactly right. When a corporation as a whole jumps into a cause like that, then you've got some elements of society wanting to stoke culture wars, my words, with
Mm-hmm.
that too. And a lot of people now are like, what, we don't want to be divided. We want to be together. We're here to make money for our shareholders. That's what we're supposed to do. And, we'll leave some of the other issues, to other formats, not us, and basing the social movements on content is, it's, of course, it's forbidden. You can't do any of that stuff when you're government, right? You can't get into
Oh, yeah.
content-based restrictions. But of course, if you've got the private sector, then you run into that challenge too. And it is exactly a fine line.
And let's take a quick break. Good Morning HR is brought to you by Imperative, premium background checks with fast and friendly service. If you don't absolutely love your current background and drug screening partner, maybe 2024 is the year to explore your options. If so, please reach out to us. We're here for you at imperativeinfo.com. If you're an HRCI or SHRM certified professional, this episode of Good Morning HR has been pre-approved for 1/2 hour of recertification credit. To obtain the recertification information, visit goodmorninghr.com and click on Research Credits. Then select episode 128 and enter the keyword retaliation. That's RETALIATION. And now back to my conversation with Julia Gannaway. So, Whole Foods didn't get sucked into retaliation, but there was a DOL case that just
Yes.
came up dealing with retaliation. An assisted living company in Massachusetts, I believe. I can't remember where it was.
Michigan.
And Michigan. Okay, it's got an M in it.
Yeah.
And their owner got in trouble, not apparently for the actual as much of the DOL investigation as the retaliation piece. What happened there?
Well, I was because this is primarily an audio content. I was screwed
Mm-hmm.
my face in doing a slight disagreement, so I have to let the record reflect that. No, but
Won't be the first time.
oh no, yeah, I've just the issue with this one was fascinating me on many levels. The way it came to our attention was business owner ordered to attend anti-retaliation training. And that was in a consent decree that the business owner entered with the Department of Labor Wage and Hour Division, and what was in it. And so that is part of it. But I wanted to touch on all of it because the whole process of this, it was Safe Haven Assisted Living Center of Haslett, Michigan, 2 T's, not Haslett, Texas. 2 T's, Michigan, and the owner, Tamisha Porter. And what happened, I think, is notable for employers to take away overall is the amount in controversy on this was $8,250 of unpaid wages. And of course, they doubled it for liquidated damages. So it was $16,500 that they owed, that the owner owed to the employees. Importantly, also, in the consent decree, it specifies there was 3 employees there at issue, 3 employees. So the employer injudiciously, according to the Department of Labor, ordered them or said, I'm going to fire you if you cooperate with the Department of Labor investigation. And that was a very bad action. They did not apparently punish her separately for that, though. So what the takeaway for that is it's, I would suspect the DOL doesn't always share with how they became tipped off to do an investigation. But once the DOL is tipped off and is at your doorstep, you have to remember as an employer that you never tell your employees not to cooperate. You make your employees available. And remember, you as a boss, as an owner, can only participate and sit in on things of supervisors. Employees, you have no, and that's for any federal investigation, but Department of Labor, they get to talk to who they want to talk to, right? Only if you're a supervisor do you have a right to have your attorney present. I think what they the amount in controversy is also scary because I would suspect strongly that Ms. Porter, if she had retained counsel, which I would expect that she did at some level, paid a lot more to her lawyer than $16,500. And usually, also for employers, make sure you check your insurance coverage, your errors and omissions coverage, because mostly those exclude Department of Labor, both judgments and
Oh, wow.
coverage, because for Fair Labor Standards Act. So be very careful of that too. That's why one of the things that I focus on when I talk to people, they may be asking me about something else, and then I ask usually an unwelcome question, such as, are they exempt? Are they non-exempt? How do you pay them? They're like, we didn't ask you that. And, but it's only if it's a natural fall where I don't just stick my snout in there. But that's the idea, though, is to ensure that they're paid appropriately. And so she had opportunities to pay it and everything. But what was interesting is part of the consent decree and a consent decree is something they agree to be entered into. So,
so she finally got smart. She finally settled it, but only after she had doubled the cost of what it would have taken to fix it the first time.
Well, yeah, exactly. And it says the defendant shall not request, solicit, suggest, coerce, or directly or indirectly any current or former employee to return or offer to return the defendant's or to someone else's someone else for the defendants any money. So they felt the need to put that in there too, like, you can't try to get this, claw this back. But they also made the owner attend a training, at least an hour training, and all managers to attend training about prohibited conduct and protected activity under the act, and with trainers to be approved by them. So
And at that point, they're just putting salt on the wound, though, because if they didn't learn it from this process, right? If they
right?
didn't, if writing a $16,000 check didn't train her, then that 1 hour of training, no matter how good the trainer
Yeah,
is not going to make a difference. But it's they at least are, but it reminds us, the thing there is, well, let's train everybody. Goes back to what we said a minute ago. Have that manager training and make sure people know what to do when these, whether it's a DOL knocks on your door, uh, or immigration, or whoever it is. Make sure you know what you're doing, and if you don't know what you're doing, don't do anything till you call
yeah,
counsel.
yeah. Just wait a minute, right? Don't be like, oh, come on in. Be like, hold up, let me call my boss or something, right? Because, sometimes they'll be like, oh, sure, what do you have questions for me? No, wait, no, 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 hold up, pause. Another thing is another thing every employer needs to ensure that they do, post those fact sheets. They had to specifically post the anti-retaliation information on this particular employer. That's part of the consent decree. But always, one of the things, you always have to post the posters. I have clients now that'll be like, hey, that's really ugly. We're trying to make everything look pretty. So why do we want to put these ugly posters? Can't we put them on the web? No. But it looks ugly. Doesn't matter.
That's the whole point. Yeah. Well, it's kind of the point, right? We
Yeah.
want these
Can we put
posters to
it,
be big and ugly so people catch
yeah.
people's eyes.
Can we put it behind the door? No. Again, see earlier answer, please, and that's an easy fix. And so, yeah, just do all of those things, but just be super mindful. I just always, whenever I see a Department of Labor wage and hour thing, I'm always like telling folks, it's like, it is something so basic, but employees are always focused on how they're paid and when they're paid. Rightfully so. They're not doing this for free. So, make sure, always double check your pay and all of those things, because
Yeah,
they,
do it right. Yeah.
they come a calling. It's not because they
Yeah.
love you. So,
Well, and there we are. We've run out of time, and we're at the end of 2024. And I just want to say thank you, Julia, for joining me today.
well, can we talk about one more, Mike? I
Oh,
know.
sure, sure,
Yeah,
sure, sure.
maybe we'll splice out some of my inarticulation at the stuff with the case, because I just had a few quick takeaways about
Okay.
the age settlement one.
Okay, the EEOC one,
Yeah,
on age
yeah. I know I
discrimination.
said
Okay,
I
let's
said
talk about
there's
that one.
really, I had some quick takeaways. I'll be
So,
good.
yeah, so tell real quick what happened on that case.
Okay, it was a molecular diagnostics company that had referred their hiring to a hiring consultant, an outside person. And what they did was they ended up hiring a 41-year-old woman instead of a 49-year-old man. The 49-year-old man sued. And I want to tell you the facts, and then here's my takeaways. What happened was they hired, again, the recruiting consultant, and it was a medical sales opening. It was the area manager of a medical sales opening job. Now, he had other experience, but he said his salary expectations, he had been making about 125 or 130, but he also said in the interview, these were the facts that were undisputed. Well, facts as in the plaintiff's case. They said that he would accept $110,000 in that decision, in that for starting salary. The training recruiter wrote those notes down, and also, wrote that he was not interested in learning the details of the job, that he was wanting to get his foot in the door with the management. So EEOC reviews his charge and accepts it. Now, what ultimately was also discovered in the lawsuit is that they pled was he, when he was not hired, said, I needed, oh, I'm so sorry. What's about the follow up? Oh, we're still looking. We're not hiring you. He goes, oh, well, can I have feedback as to why I wasn't selected? And the company said, well, you were found to be overqualified and that we were looking for someone more junior that could be trained in our product and stay for years to come.
Oh,
Well, yeah. After,
there it is.
there it is. After he scoops all that up, goes to the EEOC. Well, they they in lightning speed issue
Right.
the right to sue, pretty much, which they then sued. The EEOC sued on behalf of him because the woman, they ended up hiring a woman, um, and the EEOC said, well, they paid her more than 110,000, but her salary was 87,000. They overlook that, though, of course,
Mm-hmm.
in the grand scheme of things.
Because this was a sales job too,
This was
right?
a
So
sales
it
job.
was going
So
to be related to
she ended up,
productivity.
yeah, I'm sorry, Mike. She ended up bonusing way more than 110,000, which is what he said he would accept. But he said he would accept that as salary. I think that's a distinction. Also, though, the takeaways that I wanted to make sure and have with this is what they did not sue the company that did the recruiting. They sued only the company, and they found that the recruiting consultant was an agent of the employer. So many times, employers blindly, or not blindly, but they hire a recruiting consultant thinking, oh, that
Mm-hmm.
person's got my back. But their decisions of the recruiting consultant and the recommendations the EEOC found were bound the employer and the employer's actions. So you always have to be careful about that. It's just you can't just go, hey, someone else said it and we just acted on that. That was not a good defense in this case. But more importantly, when someone asks for feedback as to why they were not hired, please encourage your managers and everyone within hearing of my voice, either don't do it or do it very judiciously after long, thoughtful considerations. Because someone more junior, that's code for age discrimination. And also remember, as we kind of talked a little bit earlier, we can be trained in the product and stay for years to come. Really, the kind of the time that we have that people started at a company and retired 50 years later with a gold watch, that's kind of in our rear view mirror. People job hop. And that so that was rather tone deaf in the society
Mm-hmm.
today. So the biggest reason people get sued, employers get sued, is they give a reason, and the reason is a false reason
Right.
or an additional reason that the employee wasn't given, and so that's going to look like a quote unquote pretext for discrimination. So just be so careful if you decide to give feedback. Make sure that it's you can always do it, but make sure it's accurate and make sure that everyone in your company or the higher ups get a chance to consider how not only just how it can be understood, but how that reason could be misunderstood and used against you.
And it's interesting, and I don't know if you and I have ever talked about it, but I grew up in HR and was always told never give any feedback and blah blah blah, and I've always disagreed with that. And but what I tell my clients is always, if first of all, make sure your legitimate decisions are based on credible and legal reasons,
Objective
and
reasons, yes.
and you've really got and you've built a process of selecting employees that really does try to mitigate bias, and then if because every one of our applicants we've ever had thought they were the most qualified person for that job. That's just the way it is,
Yeah,
and they in the absence of an explanation, people are going to default to wondering what an unfair decision it was and what contributed to it. And the next thing you know, that's when they go talk to lawyers.
yeah,
And especially if they're in a protected class, they're over 40. What's interesting here is both parties were over 40,
exactly.
but even
That's
inside
another
that same
takeaway,
class.
right?
Right. Yeah.
You should be like, oh, I hired
Uh,
someone else, so I'm good.
yeah. She was 41 and he was 49. But, that's when people start thinking things weren't fair. And so if you really know that your process is solid and that the decisions you made were, legal and objective, and you've mitigated biases to the best of your ability, then give them some feedback. The applicants have invested time with you. They've
Mhm.
come in for interviews. They've taken off their current job. They've done all these things. it, I think that goes more to building your company brand, because that applicant may never apply again. and they may never mention your company to their friends. But if they think they were treated unfairly, you can be damn sure they're going to go talk to their friends about what a crappy company you are and how you don't, and they're going to remember that for 20 years.
Oh
They
yeah.
won't remember the nice thing you said. Hey, we really did it. We chose this other person. Here's what the difference, they had more experience or blah, 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 whatever it was. They're never going to remember that stuff in 6 months. They're going to remember why you chose somebody else, but they're going to remember the negative, the lack of, what they thought was unfair, the lack of feedback. And so, but again, like you said, that only works if you've got a good system. If you think you've got a lot of knucklehead managers going around making, bad hiring decisions based on especially illegal factors, then tell them to keep their mouth shut and don't talk to anybody.
Mm-hmm.
But then turn around and try to fix your process, because you're losing good. If your managers are doing that, I promise you, they're choosing the wrong people to start with. They're letting their own biases get in the way. And
and I was just exactly, because in Texas, I get a lot of employers that are like, well, Texas is an at-will state. And it's like, that's
nobody understands
but,
that. Yeah.
but you always have a reason. You always have a reason. So if you have a reason, say it. As long as it's not, you know what I'm saying? But I mean, if you have a reason, say it, because people will substitute their own reason. And if they feel like they've been treated unfairly, then they're going to look for someone or something to support their perception of unfairness.
And you brought it up, but I think the other big takeaway is know who your recruiters are, know who you're recruiting. If you're using a recruiter to recruit a job and to do, even just your initial pre-screening, make sure they know what they're doing, because I know a lot of amazing recruiters, and I know a lot of people who are just salespeople.
Yes.
Who got into recruiting, and they have to go both sell to the employers that we're going to recruit for you, and then they're also often the same people doing the recruiting piece, and they don't have the background to really ask the right questions and not get you in trouble. And just this case proves,
yes,
you're on the hook if that employer, if that recruiter who's not even your employee, doesn't sit in your office, does something knuckleheaded, you're going to be on the hook for it. So.
Yeah. And I just thank you for giving me the opportunity to discuss.
No, it's
too, because I thought that one had.
I always want more Julia Gannaway wisdom.
Well, I always like to visit with you, and it seems that whenever I'm not recorded, I'm much more verbally cogent. But whatever.
Well, usually when we're together, there may be adult beverages involved. I think we're probably a little bit.
Well, that just certainly it more information flows. I don't know if it's valid or helpful, but certainly more
there we go.
Info. So,
well, thank you so much for joining me, though, Julia. And you were actually 99 episodes ago, I think it was.
Really?
You were on the show, so it's been 99 episodes since then, and it's much too long.
Hopefully, I've improved, but I don't know. I mean, who knows? But I do appreciate the opportunity to visit with you and spend some time with you today. And
always a good time.
Best of luck.
And thank you for listening today and throughout 2023. You can comment on this episode or search our previous episodes at goodmorninghr.com or on Facebook, Instagram, or YouTube. And don't forget to follow us wherever you get your podcasts. Rob Upchurch is our technical producer, and you can reach him at robmakespods.com. And thank you to Imperative's marketing coordinator, Marianne Hernandez, who keeps the trains running on time. And I'm Mike Coffey. As always, don't hesitate to reach out if I can be of service to you personally or professionally. I hope you've had a wonderful holiday season, and please have an enjoyable and safe New Year's holiday. I'll see you next year, and until then, be well, do good, and keep your chin up.